Welcome back to the class video for Module 8, which we're looking at the revolutionary state constitutions and the Articles of Confederation. In the first part of class, we tried to set these documents in historical context by looking at the evolution of the colonial charters and colonial governments. In the second part of class, we looked at the core building blocks of these state constitutions, the legislative and the executive branches. The main idea to take away from that discussion is the way in which both the New York and the Pennsylvania Constitution give the preponderance of power to the legislative branch and make the executive branch subordinate to it. We want to understand this structure as the fulfillment of, or the attempt to fulfill, Paine's vision of a simple democratic government as he described it in Common Sense, or a rebellion against the Aristotelian principles of balancing the one, the few, and the many. Here in this portion of class, we want to look at a few more themes in the Pennsylvania and New York Constitution that will help set us up for the discussion, transition to discussing the Articles of Confederation, and set us up for the final segment of the course when we turn to the Federal Constitution. Now, we've already noted a few of the themes, a couple of the themes that are on your screen. We began our discussion by looking at the passages on popular sovereignty, and to remind you, it doesn't mean that the sovereignty is popular, right? That people like it. It is the sovereignty of the people. We also noted those passages that refer to courts or the judiciary, and it's worth beginning now thinking a little bit about those and the role of the judiciary in these constitutions. And we noted in that discussion that the judiciary or the court system occupies this kind of conceptually anomalous or awkward place in these models. Since we are accustomed to this Madisonian trilogy, executive, legislative, judicial, it's worth asking then, where was the judiciary before that trilogy came into existence? Or in other words, in the Aristotelian model, the one, the few, and the many, where are the courts? And why then was it so difficult if the revolutionary generation wanted to reject the principles of the one and the few and they wanted to embrace a democratic political philosophy? Why was it so difficult then for the judiciary not just to jump instantly up into the third place to form the triad? Now we can see part of the conceptual problem in the language of the constitutions themselves. So the Pennsylvania Constitution in Section 4 refers to courts of justice shall be established. And similarly in Article 40, the New York Constitution refers to the legislature of this state shall at no time hereafter institute any new courts. So there is a kind of notion that courts are created by some higher power. That is, they can't be autonomous sources of sovereignty themselves, but have to be derivative of a higher form of power. In the British Constitution, with its King, Lords, and Commons, the courts would be most commonly associated with the power of the king. The most common widespread courts in 18th century Britain would have been called the Courts of King's Bench, because the king appoints the judges. Those would be your ordinary everyday county courts and city courts and whatnot. But in a pre-modern world, in a pre-Madisonian world, there is not the idea that the only laws that can be in effect must be those that are passed by the popularly elected legislature. That is to say, pre-modern law, both British and European broadly, would have understood that there are many sources of law. The legislature and the bills that it passes that become statutes are simply one source of law. So judges are this weird kind of academic specialty, and what they do is research precedent and custom and tradition, the decrees and announcements of kings, and acts of parliament or of local city councils or whatnot. They take all of that into effect, and what they're searching for is justice, right? Fair decisions that are outcome. They're not, in other words, rigidly bound by the language of the statute passed by the legislature. That would be our modern understanding of courts, that courts work within legislative statutes, that legislatures set the bounds of court powers. They don't really have this idea yet here in the third quarter of the 18th century. It's really going to be a product of the Madisonian Revolution, and indeed not just the federal constitution, but a series of important Supreme Court decisions that really bind the U.S. court system to the language of the statutes passed by either state or federal legislatures. Now, because courts are at least conceptually empowered to determine what justice is, that is to say, their analysis transcends the power of the king and the parliament and local city councils, because they get to decide what the law is, they pose a conceptual problem for placing limitations on government. That is to say, how do you impose limits on the umpire if the umpire gets to read and interpret and decide what the rules mean? Of course, whatever limitations you put on the umpire, they're going to read it in a way that's most favorable to themselves. And so judges in courts are a kind of weird, almost semi-mystical institution or feature in the British pre-modern constitution. One of the great radical acts that both of these state constitutions are performing is by imposing limitations on courts, what we call due process rights or guarantees of court processes. So all of those clauses where they guarantee the right to trial, the right to confront witnesses, the right to know the charges against you, that bind local courts by common law procedures, those we are accustomed to because we're accustomed to the Bill of Rights and the first 10 amendments, and we see all those rights there. In context, in 1776, 1777, this is an extraordinary exertion of legislative authority or constitutional authority to bind judges to follow certain procedures. It's not at all clear in the pre-revolutionary period under British legal thinking that it's possible for Parliament to pass a law that would tell the British courts how to conduct their own business. That's a weird kind of indeterminate gray zone in all of this thinking about sovereignty. We are going to watch the building of the judiciary as an independent branch. And of course, the great power of our current judiciary in the American system is that the courts can tell the legislature that the law that they just passed is null and void, that it is unconstitutional. You may be familiar with this, and we call that the power of judicial review. Well, what is most notable here in these two state constitutions is that the judiciary is not empowered to review the acts of the legislature. As we noted in the last portion of class, both constitutions create these independent body, the Council of Censors for the Pennsylvania Constitution and the Council to Revise All Bills, which includes the Supreme Court justices in New York, but also includes the governor and the chancellor as well. It does not require a meeting of the Supreme Court, if you will. It's an independent body. So neither one of these judiciaries in these state constitutions is empowered with the autonomy that's granted ultimately to the federal judiciary, the power of judicial review. Lacking that authority here, we cannot consider them to be an independent and co-equal branch. Nevertheless, all of these due process rights and these descriptions of the procedures that courts have to follow recognize the autonomy of that, is to say, they need to be reined in the following ways. So the judiciary is this kind of mystical gray thing that doesn't quite fit in with social contract theory or theory of democratic revolution. It seems to stand apart, and what we're watching here is it slowly be folded in the vacuum created by the disappearance of the Aristotelian trilogy, the one, the few, and the many. As these Americans are moving away from that, they want to think of a different way to structure government. In the absence of those old models, these new figure is starting to emerge. It's going to come full form by the time we get to the federal constitution in a couple of modules. Okay, that by way of discussion of the judiciary and legislative review here. We can return to the text now and look for one additional theme, the way each of these constitutions treat rights. So let's look first at the Pennsylvania Constitution, because it presents kind of the classic model that we're used to from the federal Constitution. The Pennsylvania Constitution presents us with a kind of conventional organization, or the organization that we are accustomed to seeing because of our familiarity with the federal Constitution. The Pennsylvania Constitution begins with this long preamble, which is a kind of summary of the Declaration of Independence, declaring the right of revolution and to create a new government. And then we move immediately to a declaration of the rights of the inhabitants of the Commonwealth or state of Pennsylvania. In other words, a Bill of Rights or a list of specific rights. If we survey the particular rights that are bestowed, we see some general principles like all men are born equally free and independent, and also specific rights that we have analogs in the Bill of Rights. That is, the rights to protection of property with due process, the right for free elections, the right to free speech, the right of religion and conscience, the right to bear arms, all have analogs somewhere in this Pennsylvania Bill of Rights. And the rights that we're accustomed to from the Federal Bill of Rights are a kind of generic summary of the kinds of rights you would find in each of the state constitutions. Most famously, the Massachusetts Constitution has a very long Bill of Rights attached to it, and in Virginia, they never passed a constitution or ratified a constitution until the 1820s, but during the Revolution, Virginia ratifies the Virginia Bill of Rights. And you would find very similar kinds of things listed in both of those Bills of Rights. Now, if you are working on one of the rights in the Bill of Rights for your textual genealogy, then this is a rich source for you to mine for your paper topic. Whatever you're working on in the Bill of Rights, you're very likely to find some previous analog here in the Pennsylvania Constitution. So there is one aspect of these Bills of Rights that is very reassuring to us, right? It's a long list of the things that we can expect protections for. But what exactly these rights amount to, what kinds of protections are provided simply because they're written down and listed, is quite another matter. One of the things that we notice about this Pennsylvania Declaration of Rights is how aspirational the language is. It describes the broadest philosophical principles, and then uses this language of, well, this is the way it ought to be, that in order to act justly or with justice, the government should observe these principles. And so notice this recurring phrase of ought in Article 2 in the highlighted, that no man ought or of right can be compelled, or down in Article 5, that government is or ought to be instituted for the common benefit. In Article 7, elections ought to be free. And if we come even more repetitively in the next page, we see at the top of the left-hand column that they ought not to be granted. In Article 11, the trial by jury ought to be held sacred, that the right freedom of the press ought not to be restrained, etc., etc. So we notice this recurring phrase, and if we come back here to these central rights, we can get a sense of the ambiguity of that promise. If we come back to Article 5, it says that government is or it ought to be instituted for the common benefit. Well, that raises precisely the question, is it Or should it, right? And if it should be, but is not, then what guarantees or promises or empowerments does this document give me to make it so? Or you could look over in Article 8 at the highlighted passage. But no part of a man's property can be justly taken from him or applied to public uses without his own consent or that of his legal representatives. So if we hang on the key phrase there, can be justly taken from him. Okay, if I concede the point to you that it would not be just if they took it from him in another way, that doesn't quite answer the question, but can they do it even if it is unjust, right? So this aspirational language, it promises beautiful things. It promises a completed kind of enshrouding of you in all these protections, but at the same time it undercuts that promise because it says this is the way things should be. It doesn't promise that that's the way things will be. So let's come back now and look at our schematic of rights. So if we return to our illustration here in the middle row, looking at the theme of rights, and we're comparing the Pennsylvania and the New York Constitution, we notice that the Pennsylvania Constitution endorses this idea of chartered rights or enumerated rights. All that means is that the rights are listed and enshrined in a separate part of the Constitution, the Charter of Rights. So one question we could ask as we turn now to look at the New York Constitution is, since the New York Constitution does not have a charter of rights, the rights are not listed in a separate place, do Pennsylvanians have more rights than New Yorkers because their rights are chartered or listed? Do New Yorkers have no rights because they don't have a Bill of Rights that lists their rights? What we'll see as we turn to that document is that the rights there are conceived and expressed in a different way. They are unenumerated or they are embedded in reference to the governmental institutions that they limit. We'll look at that in just a second. If you recall our discussion of the difference between Lockean conceptions of freedom and Rousseauian conceptions of freedom, Locke's idea of freedom is fundamentally negative, the right to have other people not interfere with your business. The Rousseauian idea of freedom is positive. It is the ability to do things that you cannot do on your own. They are aspirational. The thing that you would like to become is your freedom, not the retreat back into the thing that you once were. And so we notice that language here in the Pennsylvania Charter of Rights, this emphasis on ought, the way you ought to be able to live if we lived in a just world. But that then raises the question of, is that ought enforceable? Is the government responsible for lifting you up to the place that would fully enshrine all of your human agency and human capabilities? Or is the government responsible merely to not interfere with you as you pursue your own freedom and agency and property and whatnot? So the Pennsylvania Charter of Rights is both aspirational, it describes the fullest possible capacity for freedom and to be endowed with agency, but it's also doubtful how those kinds of claims could be translated into actual lawsuits against the government unless the government was engaged in egregious action. So let's turn now to the New York Constitution, and in the absence of a Bill of Rights or a Charter of Rights, look for the places where New Yorkers could claim a right under the Constitution. So we have these two different approaches to describing and guaranteeing rights. One we describe as chartered rights or enumerated rights, where the list of rights is specifically spelled out and is a special section. And the other, the New York approach, we refer to as embedded rights or unenumerated rights. And the notion there is you do have a right, but it's being described in reference to the institution that's being described in the Constitution. And that's because it's fundamentally a negative right. That is, it's conceived as a limitation on whatever body is being described in that part of the Constitution. You can look at those clauses that limit government behavior and interpret it as a right of every citizen. And indeed, the language of the New York Constitution suggests that. So the question is, under which of these interpretations or applications do citizens have more rights, and are their rights more secure? We'll come back to this question when we get to the federal Constitution. You may be aware that James Madison, the primary author of the Bill of Rights, did not want to have a Bill of Rights in the federal Constitution because his notion was that embedded rights or unenumerated rights are greater protectors of individual freedoms than chartered rights or enumerated rights. And Madison's and other writers' logic on this question is the following. If I create a list of rights, say I list 10 rights, speech, religion, jury trial, right to an attorney, whatever you want. Let's make a list of 10. If there's any right that is not listed, if I give you these 10 rights, is our assumption that you do not have it because it's not on the list? In other words, once I make a list of your rights, the interpretive assumption is that list is finite. That is all the rights that you have. You do not have any others. When rights are described as embedded or depicted as embedded, they don't imply that that's an exhaustive list. It's merely one limitation, the Senate cannot do this. It's one limitation, courts cannot do that. There's no inference there that that is an exhaustive list of all the conceivable prohibitions on government. So rights remain out there in an infinite supply that courts or legislatures can draw upon. So Madison's thinking is that chartered rights, or to create a Bill of Rights, is actually to limit the number of rights because you're creating a finite list. And to aspire to positive freedom, that is, to describe the way that citizens should be able to live if we lived in a just world, is wholly beyond the reference of governmental authority. You'll notice, take for example the First Amendment to the federal Constitution. The First Amendment does not promise you freedom of speech. The First Amendment promises you that Congress shall make no law abridging the freedom of speech, right? That's a very different kind of promise. It's essentially a negative promise, right? That this other body will not interfere with your decisions. Whether you get to talk or not, whether anybody wants to listen to you, as long as the government's not interfering with you, the First Amendment has fulfilled its promise to you. It's very different than the descriptions that we see in the Pennsylvania Constitution. All right, let's leave rights there for now. We'll come back to that when we get to the federal Constitution. The last theme that we need to identify here, and we don't need to return to the text, we've already identified these clauses, is the principle of state sovereignty. And state sovereignty is the critical transition for us to start to look at the Articles of Confederation. Both the Pennsylvania and the New York Constitution contains language that declares the principle of state sovereignty. In Article 3 of the Pennsylvania Constitution, it reads that the people of this state have the sole, exclusive, and inherent right of governing and regulating the internal police of the same. The New York Constitution, in its preamble, says, by virtue of the several acts of the General Congress of the United American States and of the Congresses or conventions of this state, all power whatever therein hath reverted to the people thereof. This is a very important principle for understanding the revolutionary constitutions. You want to imagine metaphorically that with the Declaration of Independence, government is dissolved and we are returned to the state of nature. Now, when the Continental Congress passes the Declaration of Independence, they send instructions to every state capital saying, now that the old laws are torn down, you need to enact a new constitution to create your own sovereignty going forward. What's critical to American constitutional theory is that state sovereignty precedes and trumps national or federal sovereignty. So we're going to refer to this as original or plenary sovereignty, that is whole and complete sovereignty. And when we turn first to the Articles of Confederation next, we will see that it doesn't even make a claim for sovereignty, that the Continental Congress is not a sovereign body, that it defers to the sovereignty of the states. And then when we turn to the federal constitution is going to claim to be a sovereign government, and we'll look at the traits and the powers conferred on it that make it so, but it raises this conceptual problem in American constitutional theory. If the states are already sovereign, and if they were sovereign first, how can the federal government be sovereign? And out of that conflict, where can it derive its sovereign powers from? Out of that conflict, we're going to get a doctrine of what's called dual sovereignty, that the states are sovereign in their sphere, and the federal government is sovereign in its sphere, and those two spheres do not overlap with each other. And we'll have a chance to evaluate kind of the coherency of that theory given what we've read in Locke and Rousseau. So it's very important to hang on to this idea. When the Pennsylvania Constitution refers to governing and regulating the internal police of the same, that phrase police or police power is very important. It's not just cops and punishments and law enforcement. It is providing for the whole welfare of the people. So state sovereignty, because it comes first, is considered to be whole or complete or universal sovereignty. It's plenary sovereignty. When we turn now to look at the national governments, first the Articles of Confederation, and then in the last part of the course, the federal Constitution, we'll have to ask the question, where can their sources of sovereignty come from if the states already possess the sovereignty that the people are capable of conferring? So for the last part of this Module 8, let's turn now and look at the Articles of Confederation and see the way it is a kind of self-debilitating document. That is, it handcuffs the Continental Congress from acting out any real fundamental governmental powers. So we'll turn now to the text of the Articles. We are approaching the Articles of Confederation then looking for its weaknesses, right? We're looking to see what a weak central government this document creates, because the mirror image of that weakness is the dominance of the state constitutions, and that's what we want to see in the Revolutionary period. And indeed, in the first substantive article, Article 1 gives the Confederacy a name, the United States of America. The first substantive article, Article 2, begins with a declaration of state sovereignty. It reads, "Each state retains its sovereignty, freedom, and independence, and every power, jurisdiction, and right which is not by this Confederation expressly delegated to the United States and Congress assembled." Now that phrase, expressly delegated to the United States, is important. The national governments are thought of as governments of delegated powers. They only have the powers that are specifically granted to them. That's the opposite of the states, which are assumed to have plenary powers or plenary sovereignty, and so we read the constitutions or the documents exactly opposite for each. With a state constitution, because it has original sovereignty, states are assumed to have all conceivable powers except those that are specifically denied to it by the Constitution. If there's some ambiguity about whether the government does or does not have a power, when it comes to the states, because of the doctrine of original sovereignty or plenary sovereignty, we assume that the state does have that authority if there's any ambiguity. But we apply just the opposite rule of interpretation to our national governments. We assume that the national governments start with zero powers and can only do those things that the Constitution specifically delegates to them. So they're governments of delegated authority. Now, what we'll see here in this document is very few and very meager powers are granted to the Continental Congress under this document. The same rule of interpretation applies to the federal Constitution when we get to it. It only has the powers that are specifically delegated to it, but we will see dramatically greater powers bestowed on the federal government in the federal Constitution. Okay, so that doctrine of delegated powers. The Continental Congress is a government of delegated powers. It can only do those things that are specifically spelled out, enabling it to do in the document. Notice, too, in Article 3, that we're not creating a national government, we're merely creating, it says, a firm league of friendship with each other for common defense, security of liberties, mutual and general welfare, binding themselves to assist each other against all force offered to or attacks made upon them, or any of them on account of religion, sovereignty, trade, or any other pretense whatever. So really what we have here is a kind of national security alliance, not that different than, say, NATO, the way all the NATO nations get together. And yes, they make a solemn commitment to come to each other's defense when attacked externally. They make virtually no concessions over their internal sovereignty, and that's very much the conception of the Continental Congress or the Articles of Confederation. It is not a national government. It is merely a firm league of friendship. The lack of sovereignty in the national government is further affirmed and will be dramatically different when we get to the federal constitution by the lack of popular elections for the delegates to the Continental Congress. Article 5 reads, "For the most convenient management of the general interests of the United States, delegates shall be annually appointed in such manner as the legislatures of each state shall direct." So each state can do whatever they want. And indeed, the most common mode of choosing delegates to the Continental Congress is to simply have nominations and selections among the state legislatures. That is to say, you get elected to serve in your state assembly. There may also be a state senate, and that the delegation to the Continental Congress will be picked from among the sitting legislatures. That's not universally true. In Pennsylvania, uniquely, they do have elections to choose their delegation to the Continental Congress, but to my knowledge, that's the only state that does so. It does not matter how many delegates each state sends, because each state only gets one vote in the final highlighted passage. In determining questions in the United States in Congress assembled, each state shall have one vote. So, the people, figuratively, are not represented by the Continental Congress. It does not purport to represent the people. The people do not elect the delegates to the Continental Congress. Rather, it is the states that are represented in the Continental Congress as corporate bodies. So each state gets the same vote. And we'll come to this when we get to the final portion of the course. That's very controversial. That means a rich and very populated state like Pennsylvania or New York or Virginia or Massachusetts has exactly the same weight in Congress as a comparatively small or poor state like Rhode Island or Vermont or Georgia, right? They both have exactly the same say in Congress. So representation is not proportional to population. There's no principle in the Continental Congress of one man, one vote. You see how radically different that is than the principles of both the Pennsylvania and the New York constitutions in structuring their elections. Now, if we skip ahead towards the end of the document just to conclude the discussion of voting, we notice one further aspect, that it requires a supermajority of 9 votes in the Continental Congress to act upon virtually any bill. So in the highlighted passage on the right-hand column of 5, the United States in Congress assembled shall never engage in a war, grant letters of marque or reprisal, nor enter into any treaties, alliances, coin money, regulate the value thereof, ascertain the expenses for defense and welfare, etc., 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 unless 9 states assent to the same, nor shall a question on any other point, except for adjourning from day to day, be determined, unless by the votes of the majority of the United States in Congress assembled. So for any of these core functions of the Continental Congress, you have to get 9 out of 13, or it would be 12 at the start of the Revolution, and then 13. You have to get 9 out of 13 to vote in favor. This supermajority requirement makes it extremely difficult for the Continental Congress to act. Let's look at 2 other key powers of government. The foundational power of sovereignty is the power to tax, because taxation is the power to take your property away from you, right? And your property is your most sacred right in the social contract paradigm. Notice here that the Continental Congress has no power to tax. At the bottom, on Article 8, at the bottom of the right-hand column of 3, all charges of war and all other expenses that shall be incurred for the common defense or general welfare and allowed by the United States in Congress assembled shall be defrayed out of a common treasury which shall be supplied by the several states in proportion to the value of all land within each state. And that revenue has to be collected by the states at the top of the next on the next page. The taxes for paying that proportion shall be laid and levied by the authority and direction of the legislatures of the several states within the time agreed upon by the United States in Congress assembled. So the Continental Congress cannot directly tax people. The Continental Congress can spend money on the war and defense, and then the Continental Congress must apportion to each state what its portion of the bill is. And it does that based on the value of the land in each state. So if there are 13 states, let's say Virginia owns, say, 20% of all the land value in the United States. If Continental Congress spent $1 million on the war, then it would assign Virginia its share $200,000. But the Continental Congress cannot go in and collect those taxes from Virginians. It has to rely on the state of Virginia to collect those taxes and then turn it over to the Continental Congress. This was one of the greatest impediments to effectively prosecuting the war, and one of the biggest complaints of George Washington and Alexander Hamilton and the other guys who were trying to manage the Continental Army, because of course the states were perpetually coming up with excuses for why they didn't have to pay the share that the Continental Congress had assigned to them. Either they would claim we'd already paid it, or you didn't value the things that we contribute high enough, or you don't have the power to, or simply that our state priorities our state expenditures must take priority, and we will remit to Congress whatever is left over in surplus after we pay off our state bills. Well, in the absence of an authority to go in and tax for themselves, the Continental Congress was utterly at the mercy of the states, and it created utter chaos and fiasco in the financial management of the war. Again, this is one of George Washington's biggest complaints about the Continental Congress, is that it lacks the power to tax, but it's the absence of its power to tax is the biggest red flag marker that this government is not a sovereign government. It doesn't purport to be a sovereign government. If it was sovereign, it would be able to take the property of its citizens. So the power to tax is a big one. And then let's look finally, because we were talking about the judiciary and the state constitutions, notice that the Continental Congress and the Articles of Confederation proposes no federal judicial system. In its place, we have Article 9 and this utterly confusing and convoluted process for resolving conflicts between states. If we look under Article 9 in the second paragraph, the highlighted passage there in the left-hand column, the United States in Congress assembled shall also be the last resort on appeal in all disputes and differences now subsisting or that hereafter may arise between two or more states concerning boundary, jurisdiction, or any other cause whatever. And then in the remainder of the paragraph, we get this enormously complicated system whereby we're going to pick jurors essentially by lot or at random through a succession of kind of cullings, and then ultimately this group will be able to go out, and this party will be able to go out and review the evidence and render a decision. This is the substitute for having a federal judiciary. It is an utterly unworkable process. You can imagine all of the lawsuits that get filed between residents of different states and between states themselves over land and other issues. And this is the method that the Articles of Confederation prescribes for resolving all those conflicts. In the absence of sovereignty, They cannot propose a national judiciary that would have the right to interpret the Constitution. They have to defer to state sovereignty and state judges, and so they're left with this miserably convoluted and impossibly complicated system for resolving legal disputes. All right, let's look at one final passage before we summarize that we'll want to return to. If you notice on Article 13, the Articles of Confederation do contain a provision for their own amendment. Article 13 reads, "Every state shall abide by the determination of the United States and Congress assembled on all questions which by this Confederation are submitted to them. And the articles of this Confederation shall be inviolably observed by every state, and the Union shall be perpetual. Nor shall any alteration at any time hereafter be made in any of them, unless such alteration be agreed to in a Congress of the United States, and afterward be confirmed by the legislatures of every state." So the articles do contain an amendment provision. You can amend the articles within the terms of the articles. Notice that it requires a unanimous agreement. Every state must agree to any changes to the articles. One of the questions that we will confront when we turn to the federal Constitution is, how could the Federal Convention propose a brand new document to start from scratch with a new government rather than working within the framework of the articles? And the answer is they just blatantly violate this clause of the Articles of Confederation, and that will be a major complaint of the Anti-Federalists. When we get to Melancton Smith, he will make a big argument of that fact, that Article 13 of the Articles of Confederation says the articles shall be perpetual, and they can be amended within its terms. Where does James Madison get off bringing back from the convention a wholly new document that just throws the articles in the dustbin and ignores them, and he's asking us to go with this new frame of government? So we'll come back to this. Article 13 is very important when we get to the federal Constitution. But looking at these key clauses, and again, the emphasis is upon the powers that are not here. Right? Let's return to our illustration and try to summarize this module. So we can see here the major provisions of the articles on the right-hand side of the screen, that it is merely a league of friendship, that it does not purport to create a national government, that it's one vote per state governed by a 9-vote majority, that its powers are primarily focused on foreign relations and security, that it's a kind of national security alliance. The absence of a federal judiciary, the absence of a taxation power, and its amendment provisions. The key thing to understand about the Articles of Confederation is that it does not purport to represent the people. It purports to represent each state as a corporate entity, and therefore each state has equal influence, even though they may be paying dramatically more or less as their share of the burden for sustaining the Confederation. Certainly Virginia and Massachusetts, New York and Pennsylvania are going to be paying much, much more in taxes into the central government than the smaller and poorer states, yet they each get one vote despite that difference. And we're going to come back to that conceptual problem in representation when we get to the federal Constitution. As we prepare now to turn to John Adams's piece, The Defense of the Constitutions of the United States, we will see Adams describe the Articles of Government as, he says, Congress is not a legislative assembly, it's not a representative assembly, but only a diplomatic assembly. And we'll see in there the reflection, again, this mirror image, the weakness of the Continental Congress, of the central government, reflects the strength of the state governments in obverse. And that is the fulfillment of the revolution against a powerful central government, i.e. Parliament and the king. The Americans are not going to, immediately after fighting a war against a powerful central government, turn right around and create another powerful central government. But we'll see as we get to the next module and we read Adams's critique that not everyone is satisfied with that form because it forgets fundamental principles of Aristotelianism. And so what we want to see as we turn to John Adams, whereas in Tom Paine we saw the most zealous, enthusiastic endorsement of the principles of democracy. And in these state constitutions, we see a remarkable fulfillment of that vision. Now we're going to see the other side of the spectrum. John Adams is very nervous about the radicalism, the democratic radicalism of these state constitutions, and he's going to start cautioning about the limits of democratic freedom, and that's why we need bicameral legislatures. So we'll turn to that next in Module 9.